Estelle Griswold from Planned Parenthood. Will you please provide us with contraception for sexual stuff?
Are you married?
Yes.
I guess you guys can have contraception. Thank you.
Thank you. Action.
Ms. Griswold, I'm arresting you for providing illegal contraception to married couples of Connecticut.
On behalf of my client, we are appealing the court's decision that the use of contraception is illegal as it is unconstitutional.
The court appears rules that any person who uses any drug, medicinal article, or instrument for the purposes of preventing conception shall be fined not less than $40 or imprisoned not less than 60 days.
Judge Douglas and other members of the Supreme Court, we are here today to appeal the decision of Connecticut's ruling that Griswold's dealing with contraception was illegal as it is, in fact, unconstitutional.
The Supreme Court will overturn the decision of the Supreme Court of Errors of Connecticut due to the fact that the right of privacy is fundamental when it concerns the actions of married couples, because it is of such character that it cannot be denied without violating those fundamental principles of liberty and justice.
In terms of constitutional issues, the right to privacy was in consideration. It was a landmark case because it furthered the right of privacy and changed millions of women's lives. Over the next 10 years, the court expanded this fundamental, substantive right to privacy beyond the marital bedroom, ruling that the state could not ban the use of contraceptives by anyone. The lower court rulings upheld conviction of Griswold because they did not want to change the law set in place prior. The Supreme Court ruling ruled in favor of Griswold and ruled the state of Connecticut's law unconstitutional.
Hi, I'm Linda Brown and I'd like to go to your school.
I don't think the Public Education Board would approve of you being in our school due to your race. I'm sorry, young child. You're going to need to leave. You're not welcome here.
As the judge presiding over this court, it is my ruling that under the court case Plessy v. Ferguson, that segregated schools, be they separate but equal, are in fact constitutional.
As Chief Justice Earl Warren, the segregation in schools goes against the 14th Amendment Protection Clause and should be overturned. This means that we are overturning the Plessy v. Ferguson separate but equal.
This issue violated the Equal Protection Clause of the 14th Amendment with the separate but equal. It was a landmark case because it overturned Plessy v. Ferguson and desegregated schools. The lower court ruled separate but equal was constitutional. The Attorney General of the states permitting segregation in public education have appeared as animus curiae upon request in 1954. The Supreme Court ruled that segregation in public schools was unconstitutional. The Supreme Court granted plaintiffs' petition for the writ of certiorari on October 8, 1952. The court then combined Brown with a South Carolina school segregation case, Briggs v. Elliott. After the case was closed, the judges and officials had a judicial conference to improve immigration laws. The Warren's court unanimous decision was 9-0. This paved the way for integration in schooling.
Being a Jewish family in America, we do not believe that our child has to say prayers before class in a public school.
By instituting these prayers, it is not our goal to establish any one religion.
Well, we would like to have the prayers in school stop. And if you do not stop it, we will be forced to go to the courts.
The New York Court of Appeals will allow school prayer in public schools. The Supreme Court rules that this school prayer violates the Establishment Clause of the First Amendment which states Congress shall make no law respecting an establishment of religion.
This issue violated the Establishment Clause of the First Amendment, which states, Congress shall make no law respecting an establishment of religion. It was a landmark case because it made prayer in public schools illegal and led the way for many public school religious affair cases to be made unconstitutional in the future. The New York Court of Appeals allowed the prayer reciting Almighty God. Engel petitioned the U.S. Supreme Court for a writ of certiorari, after the New York Court of Appeals affirmed the lower court's decisions to allow prayer in public schools. Governments of 22 states signed on to an amicus curiae brief urging the affirmation of the New York Court of Appeals decision that upheld the constitutionality of the prayer. The Supreme Court ruled that reciting prayer in public schools was unconstitutional.
You are under arrest for the attempt to commit petty larceny and breaking and entering. Action.
Mr. Gideon, I'm sorry, but I cannot appoint counsel to represent you in this case. Under the laws of the state of Florida, the only time the court can appoint counsel to represent a defendant is when the person is charged with a capital offense. I'm sorry, but I will have to deny you your request to appoint counsel to defend you in this case.
The United States Supreme Court says that I am entitled to be represented by counsel. So
Mr. Gideon, the jury has found you on the counts of breaking and entering and attempt to commit petty larceny guilty. You are sentenced to 5 years of Florida State prison. You can cry.
I'm writing my appeal to the Supreme Court because I was unfairly represented by myself.
The Sixth Amendment does not distinguish between capital and non-capital cases, and you may be appointed a lawyer.
The Supreme Court decided that the Sixth Amendment guarantees also apply to the states as the 14th Amendment and Due Process Clause outline. This is important as they found that the Sixth Amendment's guarantee to counsel is a necessity to a fair trial. Gideon v. Wainwright is a landmark case as it overturned the decision of Betts v. Brady and established the right to an attorney for every criminal case. The case regards the ruling of a Florida and state court for the lower court rulings that decided that a man being charged with a non-capital crime who couldn't afford legal counsel could not be appointed such as the state law permitted such for capital cases only. After applying to the Supreme Court for a writ of habeas corpus, the Supreme Court overturned the prior ruling of Betts v. Brady and determined that fair trials before impartial tribunals in which over-defendant stands equal before the law cannot be realized if the poor man charged with crime has to face his accusers without a lawyer to assist him. This provided that everybody has right to legal counsel if it cannot be afforded.
You are under arrest for committing. Start that over. Sorry, I'm. Can you just please point or something? That's so confusing. Okay.
Just say go.
It's already started, man.
Are you serious?
We'll just cut it out.
Oh my god. You are. You are under the arrest for the intent to commit petty larceny.
Oh man, I had the camera pointed the wrong way. Oh no, I didn't. Okay.
Just jump.
Okay.
It's still recording.
The Sixth Amendment states that it, oh, just kidding. Wait, I said it wrong. Okay, just start over. I have to say distinguishes. The Sixth Amendment distinguishes between, wait, oh no, what did I say? Does not distinguish. Okay, I'm sorry, keep going. The Sixth Amendment does not distinguish between capital and non-capital cases, and you may be appointed as lawyer. You kidding me?
Sorry. Hello, I'm Judge.
Cut. Try again. Ready and.
That states that.
Cut. Try again.